This morning, a key chapter in the first ever criminal trial of an American ex-president came to a close. The testimony phase of the people of the great state of New York versus Donald J. Trump is over after the defense rested its case, and Trump, in the end, costing my friend Vaughn a stake, did not testify. Although just a few weeks ago, he said this, quote, "I'm testifying. I tell the truth." Whatever that means. Happening right now in court, prosecutors and Trump's defense attorneys are discussing the instructions that Judge Juan Merchan will give to the jury when they get the case. It's dense and complicated, but incredibly important, especially in a case like this one, where Donald Trump faces 34 felony charges for falsifying business records in order to conceal another crime. We'll keep you posted on all of the updates out of those proceedings, but we turn now to the dramatic events this morning in court. Team Trump resting its case after putting on the stand just two witnesses. One was a paralegal and the other was the attorney Robert Costello. And whatever credibility he had left after his outbursts in court, the ones that resulted in Judge Merchan clearing the courtroom to admonish him, whatever remained was ripped to shreds in a matter of a few explosive moments during cross-examination this morning by prosecutor Susan Hoffinger. With jurors reportedly paying close attention, the DA's office showed emails written by Costello himself that clearly show that he worked to manipulate Michael Cohen, even as he claimed to be his lawyer. He wrote in an email to his partner Jeff Citron that they needed to get, quote, Michael Cohen on the right page without giving him the appearance that we are following instructions from Giuliani or the president. In my opinion, this is the clear and correct strategy, end quote. Then the prosecutor, Susan Hoffinger, threw his own words back in his face from NBC's reporting from inside the courthouse, quote, as you said yesterday, Hoffinger asked, quote, the email speaks for itself, correct? Costello's reply, quote, sometimes. Prosecutors also entered into evidence another email from this attorney, Costello, to Michael Cohen that read, quote, you're making a very big mistake. If you believe the stories these journalists are writing about you, they want you to cave. They want you to fail. They do not want you to persevere and succeed. If you really believe you are not being supported properly by your former boss, then you should make your opinion known. Then there's more. The DA's office showed an email from Costello to his own partner that read, quote, tune into CNN and see how they're playing this up. He has to know this. He just continues to slow play us and the president. What should I say to this a-hole? He is playing with the most powerful man on the planet, end quote. No wonder he didn't hire him. No surprise then that Michael Cohen, the Michael Cohen, is the one that puts distance between himself and this guy, this lawyer, Costello. You'll recall he testified last week to this, quote, there was something really sketchy and wrong about him, end quote. Now, all of this whole testimony phase of the Trump election interference hush money trial coming to an end with a gamble gone wrong by Team Trump is where we begin today with some of our favorite reporters and friends. With us at the table, former top prosecutor at the Department of Justice, MSNBC legal analyst Andrew Weissmann, plus New York Times investigative reporter Suzanne Craig is back with us, the former executive editor with American Media Inc. and special correspondent for The Hollywood Reporter Lachlan Cartwright joins us, and special on-set guest, NBC News correspondent Vaughn Hilliard has made his way from the courthouse to be with us on set. I want to show you guys, because you've constantly reminded me that there are some very able attorneys sitting at Trump's table. The Costello thing seems like a debacle to me. Again, I speak only as someone who's been picked to sit on a jury, not as anyone who's ever prosecuted or defended anyone in a criminal context. But this is what Fox News was saying about the kill shot that this Costello character could deliver.
Quite frankly, Costello is a kill shot witness.
After I just heard from Bob Costello, I think Trump should put him on as a witness.
If Michael Cohen didn't already totally destroy Bragg's prosecution, there's one potential witness. Now, Martha said there might not be any other witnesses called, but there is one who could deal the final blow, perhaps, former Cohen legal advisor, unofficially, Bob Costello.
Did they want him to implode? What did they want?
Let's start with, you don't know how a jury is going to take any of this. And so I'm going to give my opinion as somebody who's litigated. I don't know how it's playing to the jury. There are things that didn't make any sense in terms of how to try this case. I've talked about, I do not understand why you give a hard cross to Stormy Daniels, whose evidence was, it doesn't matter whether you believe her or not, but you don't do a hard cross on David Pecker and Hope Hicks, who had really damaging testimony. So that has to be coming from Donald Trump, not from a good defense team. Robert Costello, if you are the prosecution, you had to be going, thank you. I think he did provide a kill shot, but not in the way that Fox News intended. This was devastating evidence. It was an exhibit to exactly what Michael Cohen had said was going on. It is so mob. It is exactly what happens in mob cases where you have lawyers sent in to find out, are you cooperating? We really represent the boss. We're trying to, that's who we really are doing. That is what the jury could conclude. Obviously, the witness said that's not true. The problem for him is you were reading from, it's in black and white. And Michael Cohen said, I didn't trust him. I thought essentially everything was going to get passed up to the president. And there it was in black and white. And that is why he didn't hire him.
So again, I try to say this at least once every hour. We have no idea how the jury has received any of this. But if this is an exercise in relativity, relative to Michael Cohen, who's a bigger thug, Donald Trump, the guy who's on trial, or me, I mean, Costello points the Klieg lights back to Donald Trump.
You would have thought that the hard part for the prosecution is ending the case with Michael Cohen. That was a pretty bold move. Usually you sandwich him, with other stuff, and you end with like a more innocuous witness who's like, here's some records, something like that. But that issue was solved by the defense putting on their first witness, who was a paralegal, who basically said, you know what Todd Blanche told you and stretched the truth about the 75 calls, that was wrong. And I'm not going to be a fall guy for that. So that was like a little amuse-bouche to the real issue, which was that Costello got on, and I just thought there was such a huge mistake. Plus, Costello had been in the grand jury a year before, so the prosecution knew exactly what it was going to say. They get a year to prepare for this. And Susan Hoffinger, if you want to see really good lawyering, Susan Hoffinger's cross-examination was masterful.
Okay, so we're going to read it. This is what happened, Suzanne. Mr. Cohen. Actually, this is from Cohen's testimony on May 14th. Mr. Cohen, did you ever tell the truth to Mr. Costello about Donald Trump's involvement in AMI's purchase of Karen McDougal's story to prevent that coming out before the election of Donald Trump's involvement and direction to you paying Stormy Daniels to prevent her story from coming out? So was Costello in possession of the truth? Michael Cohen, no. Why did you not tell Mr. Costello the truth about Trump's involvement in those matters? Cohen, this is on direct. I didn't trust him, meaning Bob Costello, and I was still remaining loyal to Trump. Question, did you believe that if you told him the truth that he would tell that to someone? Cohen, yes. Who did you believe he would tell it to? I believed, based upon all our conversations, that he would immediately run back to Giuliani and that our communication would be divulged to President Trump. So this is yesterday when they cleared the courthouse. Right. We didn't know when we were all here together yesterday, when we were on the air at 4, what had happened, but it wasn't sealed, so it was released in the transcript last night. The judge. Okay. So when there's a witness on the stand, if you don't like my ruling, you don't say, geez, okay? And then you don't say, strike it, because I'm the only one that can strike testimony in the courtroom. Do you understand that? Costello, I understand. Mershon, okay. And then if you don't like my ruling, you don't give me side eye and you don't roll your eyes. Do you understand that? Do you understand that? Costello, I understand that. I understand what you're saying. The judge, okay, thank you. Now let's get the jury back. Are you staring me down right now? Costello, no, I'm just wondering how. The judge, clear the courtroom, please. Clear the courtroom. The judge, all right, let the record reflect that it's now 5 after 4. I'm putting you on notice that your conduct is contemptuous. If you try to stare me down one more time, I will remove you from the stand. I will strike his entire testimony. Do you understand me? Trump's lawyer, yes, Judge, I understand. Judge Mershon, listen to the question and answer the question. Costello, can I say something, please? Judge Merchan, no, this is not a conversation. Costello, okay.
Yeah.
So that was yesterday.
Yeah.
And then today, they bring the prosecution back to its strongest witness, documents.
Right. I mean, it was really, going through those emails was incredibly powerful. And at a certain point, if it looks like a rat and walks like it is a rat. And that's exactly how he came across in the courtroom. Once those emails were read out, they were incredibly powerful. Hoffinger's cross, it was really, I mean, it was masterful. I mean, she just kept it right, locked on him tight, and got him through it. And I thought it was efficient too, and I think the jury probably appreciated that. I thought all of it was very smart by them. I just am still marveled by the fact that they, from their own discussions and when they're processing Cohen, they think they really landed some shots. So if we just think about that, on the last day of his testimony, he admitted from stealing from the Trump organization. So he's admitted to stealing, he's admitting to lying. And instead of letting that linger with the jury, they let this happen. And now the jury's gone for a week, and the last testimony in their mind is Costello. I mean, it's really something.
Defendant Trump there, passing on an opportunity to engage the press corps that's assembled for him, but maybe he wasn't as interested in the question about what was confirmed today. He will not be testifying in his defense at this trial, as is his right. We are now, as promised, joined by Andrew Weissmann, former FBI general counsel and a senior prosecutor in the Mueller probe. Welcome, Andrew.
Nice to be here.
Jury instructions are boring but important. Agree?
Totally
And
agree.
we don't have it all set yet. I like to be very clear with people. We don't have them all. When we get them, we'll be reading them, and we can kind of announce whether they seem really standard or slanted any which way. Let's start, though, with the wrangling over instructing on the campaign crime and the money. Tell me about that and what you thought you heard.
Well, there was one part that I thought was really interesting and good for the government, and it's that the state, in order to make this a felony, has 3 separate crimes that they're going to point to say if you committed this false business records, but with the intent, just the intent to aid or conceal another crime, you've got this felony. And they pointed to 3 separate crimes, 1 federal, 2 state. And one of the arguments was, does the jury have to be unanimous about which of the 3? In other words, if you have 6 saying it's this one and 3 saying it's that one and 3 saying it's that one, is that sufficient? Or do they all have to be 12 saying it's this one? And the judge says, as long as it's unanimous that that they all agree that at least 1, but they don't have to agree on the same one, that it's sufficient.
Which is bad for Trump.
Bad for Trump.
Can I make a crack comparison?
Yes.
So if you're doing a crack prosecution, but there's a possibility that the powder was illegal fentanyl, street fentanyl, instead of crack. As long as you can get the jury on board that this was illegal substance, contraband, right, you're good. And that's sort of the analogy here. If you're going at a drug charge, right, you don't get to say, oh, no, you guys are different crime. Yes, I clearly have 12 people who think I committed the crime, but they're split on it if they are bundled together like this.
Yeah, I mean, that's an analogy. It's basically I guess you said we're going to be in the weeds.
Let's go.
Gardner.
Yeah.
The legal term is that it's methods and means. In other words, the methods and means by which you carry out a crime is not something that the jury has to be unanimous about. They have to be unanimous about what's called the elements of a crime. Every crime has certain elements. That there has to be unanimity. But this is a good ruling because there's a sort of a smorgasbord of choices, and you do not have to have unanimity. That, I think, was really useful.
And that reminds, I think, people who've been following the trial that there was so much emphasis on what Trump's intent was in covering it up, right?
Exactly.
And so, again, if you want to be as fair as possible, and there's a defense that he had these other legal reasons to cover it up, in court of public opinion, people may judge it, voters may judge it, the Christian right group of political Republicans used to judge that, but that's separate. Here, the only thing is, to your point, can they demonstrate, and the jury instructions demand, that he's doing this to cover up some other crime. And if you're saying disagree on which crime, that's okay.
Yeah, and the other, to your point, this came up, and then the judge dealt with this issue in the jury charge. What if the state proved that 50% of what Donald Trump was thinking was campaign violation, and 50% was Melania personal,
right. Real existential type division, okay,
or if it was 90-10, or you make up your own hypotheticals in math. What does the law require? Does it have to be 100% campaign or tax, or what if there's some portion that he was thinking about just protecting his family? And the law in New York, and the judge basically said this, is that it does not require the state to prove that it's 100% campaign.
Right, which would be odd.
Exactly. And so the judge said, no, there has to be, you can have dual motives. The state doesn't have to prove that the only reason that you were doing this. Now, obviously.
Well, let me jump in. I mean, someone could have a big public-facing job. They're the CEO of a big company, and there's evidence that they beat up on their wives, let's say. Their motivation might be to avoid embarrassment and also avoid the fact that they allegedly committed a crime of battery, right? The fact that they're also worried about losing their job, which is not legal, or being embarrassed or being kicked out of their country club, that doesn't extinguish and vitiate the illegal intent, no?
Exactly. And so we'll know exactly what language the judge is going to use on Thursday. One of the things that Judge Merchan, who's just been spectacular, is doing is he's going to make sure on Thursday that the public and also all of the parties see exactly what he's going to charge the jury. Why is that important? Because as you and I know, when you're then preparing your summation, you want to know, well, what's the judge going to say the law is, so that you can address that in terms of telling the jury, this is why we have established the facts, or on the defense side, this is why they haven't established it. But you need to know what you're sort of shooting against. And so the judge is going to give that to them with plenty of time to be able to prepare.
Yeah, and that'll be what? I'm going to keep you over the next break, but briefly, that's just a couple pages what we ultimately get.
Oh, it should be long.
How long do you think it'll be?
It could be like 30 pages of jury instructions. Yeah.
Wow.
It's long.
That's longer than I was thinking.
Yeah, they're long.
Because of the theory of this case, or in general?
In general, jury instructions are long, and and then the judge sometimes will actually give the actual charge. They'll print it out and give it to the jury.
And do the checklist.
Less than 2 weeks before the presidential election, Michael Cohen wired $130,000 to Stormy Daniels' lawyer. That payment was to hide damaging information from the voting public. The scheme violated New York election law.
That's the case, as described by D.A. Bragg. We are back with Andrew Weissmann. We turned finally to 2 days of defense, and they had a rough 2 days. Here's one moment people have seen from what I call the hot mess of this Giuliani ally, Costello. The judge says, listen to the question, answer the question. We're dealing with a lawyer and former prosecutor. It's worse when you break the rules and you know them so well. He says, well, can I say something, please? And that is kind of how he talked, so I'm being fair. That's a decent reenactment, Andrew. And the judge says, no, this is not a conversation. He knew better. He still acted this way. Was it a hot mess? Did he hurt the defense effort?
And that, by the way, that quote is maybe the least of it. He said he said twice to him, the judge to the witness, outside the presence of the jury, your conduct is contemptuous. He was a huge mistake. It is better to not put on a witness if you're the defense than to put on a bad witness. The jurors are going to be like, you had a defense and this was your defense. Here's what I think the state is going to argue in summation. They're going to be saying, you saw an obstruction scheme. You saw it in black and white that was orchestrated by that man, and they will point to Donald Trump, and it was carried out by Bob Costello and Rudy Giuliani. And what was the goal? To have Michael Cohen never take the stand. You do not do that if you are innocent. You do not do that if you are not worried about Michael Cohen. And so they will use it to show consciousness of guilt. They will use it to show that Donald Trump is a ringleader and the head of this group. And they will use it to sort of rehabilitate Michael Cohen, to say they knew exactly that he had the goods.
I got 30 seconds left with you. Is that case stronger with the defense having put him on?
The state's
case? The DA's ability to bloody it,
Absolutely. This was a huge mistake. I know some of the defense lawyers cannot imagine this was their choice, that they are too good to be thinking.
So bad it looks like malpractice, but maybe Trump forced them into it as a client, you're saying?
Well, the client can, it's not forced, the client
you know what
can
I mean?
make the
demanded
client,
it.
Exactly. The same way that, listening to Donald Trump say, I wish I could have testified, just to be clear, it's his choice.
Good evening from New York. I'm Chris Hayes. Well, after 5 weeks, the first criminal trial of a former U.S. president is nearly over. The defense rested this morning. It called only 2 witnesses. And despite all his bravo and insistences to the contrary, Donald Trump was not one of them. I mean, we knew that, right? Instead, we heard briefly from a paralegal at attorney Todd Blanchard's firm about phone records before a man by the name of Robert Costello took the stand. Now, Costello is a former federal prosecutor, a very close associate of Rudy Giuliani, the twice indicted former mayor of New York City. We'll have more about him later in the show. And also Donald Trump's personal attorney while he was in the White House, Giuliani, that is. I think it is fair to say that Costello's testimony this week backfired on the defense, though how much remains to be determined. But Trump's attorney's main reason to put that man, Robert Costello, on the stand was to directly contradict and impugn the credibility of the prosecution's key witness, Michael Cohen. But I gotta say, turns out Robert Costello might be the only person in the country who can make Michael Cohen seem even-tempered by comparison. Costello began his testimony yesterday acting like what can be best described as a petulant teenager, rolling his eyes, muttering under his breath, at one point saying that something would be to strike something. Of course, that's not his job, that's the judge. And then after sort of crossing the judge, tried to stare him down, at which point the judge was like, "Are you staring me down?" Cleared the courtroom. After clearing the courtroom, the judge called Costello's conduct, quote, contemptuous, in the sort of technical narrow sense of contempt of court, and threatened to remove him from the stand and strike his testimony from the record. That man, Costello, again, the big star witness for the defense, right? The one person they're putting up, returned to the stand today for cross-examination. Now, remember, at the center of Costello's testimony is a 2018 meeting he had with Cohen. That's after Cohen had been issued a search warrant or had a search warrant executed by the FBI. And as Cohen tells it, he's having these back and forth with Costello, who's putting a very kind of high-pressure sales job on him, the implication of which was that they had to kind of keep Cohen in Trump's circle to prevent him from flipping, that, Costello was aligned with Rudy, who was aligned with Trump, so hire me, you'll stay in the circle. Now, Costello says he was just there to offer his legal services. So that's the sort of main battle here, right, over what happened. And today, prosecutor Susan Hoffinger asked Costello, quote, "You discussed with Cohen at that very first meeting how connected you were to Rudy Giuliani, correct?" And Costello responded, quote, "That's not true." Hoffinger then read Costello an email Costello wrote to Cohen 2 days after that meeting, which stated, and we quote here, "I am sure you saw the news that Rudy is joining the Trump legal team. I told you that my relationship with Rudy could be very, very useful to you." Again, Costello's words. The prosecutor also read an email he wrote to a legal partner the same day, not to Cohen, quote, "All the more reason for Cohen to hire me because of my connection to Giuliani, which I mentioned to him in our meeting." So, again, you mentioned Giuliani in the first meeting. No, under oath. Well, let me read 2 emails here in which you're like, I mentioned Giuliani. Okay. In further communications, it's clear that Costello continued to dangle his relationship with Giuliani and, again, by extension, Donald Trump, over Cohen's head. In another email from Costello to Cohen, he wrote, quote, "I spoke with Rudy. Very, very positive. You are loved," which I will say is sweet. Adding, quote, "There was never a doubt that they are in our corner. Rudy says this communication channel must be maintained," end quote. "Sleep well tonight. You have friends in high places." Also sweet. P.S. Some very positive comments about you from the White House. Now, you may be thinking that the invocation of Giuliani and Trump repeatedly in written communications by this man doesn't definitively prove Costello's intentions. But in a stunning example of something you really don't want to put in writing, prosecutors then today read another email, again from Costello, to that same legal partner. Quote, I'm quoting again, "Our issue is to get Cohen on the right page without giving him the appearance we are following instructions from Giuliani or the president." And I got to say, when you put it like that, it sure sounds like he was following instructions from Giuliani and the president, doesn't it? So the defense's final act, their one big witness, did not, I think, do a great job exonerating their client or even sort of knocking down the credibility of the man that he was supposed to knock down, Michael Cohen. Now, I got to say, I've followed this trial very closely, not as closely as some of our next guests who've been in the courtroom every day. But, excuse me, I find Michael Cohen, on the core matters of fact that are relevant to the charges, believable. That's in large part due to the extensive documentation provided by all kinds of people, including Robert Costello himself. Not to mention the lengthy paper trail outlining each step of the scheme to repay Cohen for the hush money he paid to Stormy Daniels to cover up the sexual encounter she had with Donald Trump. The attempts to hide those reimbursements in the form of bogus legal payments. The basic contours of all that, like, was Stormy Daniels paid? Did Cohen paid for it? Was he reimbursed? All of that's not really in dispute. A week from now, when closing arguments start, this will all be in the hands of the jury, and they're going to ultimately decide the ex-president's fate. Joining me now are two people inside the courthouse today, MSNBC legal correspondent Lisa Rubin and New York Times investigative reporter Suzanne Craig. It's great to have you both here. So I missed the Costello fireworks yesterday. Jen Psaki had her show on Mondays. I don't have one on Mondays. I was following it. I was even texting with Lisa being like, is this as insane as it sounds? So let me just go back a day because I wasn't there. Like the Costello experience in that courtroom.
Well, you're not going to sell me out by reading my response. My response was beyond in all caps. The Costello experience in the courtroom is a really good instructive lesson on how demeanor matters, because you can say all sorts of things about your misdeeds, and so long as you remain polite and contrite and succinct, jurors might believe you, and Michael Cohen is an illustration of that. Yeah. What was so bizarre is that the Robert Costello that we saw over the last couple days reminded me of the Michael Cohen that we saw at the civil fraud trial.
Which was exactly the fear of everyone around the prosecutor's office.
Correct.
For this trial.
Right. Even to the point that in the same way that Costello said, strike that, or the email speaks for itself, which is also something lawyers say in defense of clients, for example. Michael Cohen at that civil fraud trial would say from the witness stand, asked and answered, right? Very bombastically. So the role reversal was very telling. But I want to read you, Chris, another email that came out with Robert Costello today toward the end, because it is maybe the worst example of how Costello was just seeking to advance Donald Trump's interests and not Michael Cohen's, as he swore. At one point, he writes to his partner, Jeff Citron, who is the person who had a relationship with Cohen, and says,
who introduced the two men.
Correct. And says, tune into CNN and see how they are playing this up. Cohen has to know this, yet he continues to slow play us and the president. Is he totally nuts? What should I say to this blank hole? He is playing with the most powerful man on the planet. And by that, Costello, despite his high opinion of himself, didn't mean him, right? He meant Donald Trump.
Right. Can we just put that, we have that full screen. What should I say to this blank hole? He is playing with the most powerful man on the planet, which is like, right. So the story Cohen is telling is, you're Donald Trump's dude, and you're there to get me. And then he's writing this. What did you think of the cross of Costello today?
Well, I just first want to give some props to the sketch artist who was in court, who caught that moment. We just had it up.
Oh, the stare down.
Yeah, the stare down where the judge is like, whoa, right there.
It's a good.
Yeah.
You're right.
You don't often see that sort of thing from
shout out Jane Rosenberg.
Yeah, shout out, definitely. So what did I think of the cross-examination today when the government got back up? I thought it was incredible. I mean, just how she dissected him in the amount of time and just got right to those emails and just, I think, laid bare that he was an agent of Giuliani and Donald Trump. And no wonder Michael Cohen, you know, the whole premise of having Costello up there was to discredit Cohen, because Costello could come and say, well, he never admitted that he made these payments to me. And Michael Cohen has said, I was really suspicious of this guy. Well,
no wonder.
No wonder. I was going to say, know something, Sherlock.
Yes. And we should say there's one piece of testimony Costello gives that where he says Cohen told him, I don't have anything on the president. And in some ways, you know, that's relevant. And I can see if the defense, you want to get that in. Like, look, we talked to this guy and he was like, I got nothing. So you want to plant the seeds that he invented it later, right? Ex post facto. But given the broader contours, there's two stories here about this interaction. Right. And the Cohen story, again, to my mind, from the testimony I saw in that room when I was there and from the emails, like the Cohen story seems to match the other evidence much better than the Costello story does, right? Is that fair?
That's absolutely correct. And there's also another problem with Bob Costello's story. In order to credit Bob Costello's story that Michael Cohen eventually lied, you have to believe that he was telling the truth to Costello at some point in time, which means Michael Cohen tells the truth at some points in time, right? So it's sort of facially ridiculous at some point for Bob Costello to be Michael Cohen's a liar because his entire testimony is premised on Michael Cohen telling him the truth for some period of time.
Right. And that's going to come, Michael Cohen, he's a liar, he's a cheat, but this case is going to come down to the jury believing, at least at some point, he can tell the truth. It's not binary. It's not like he always lies or,
Correct. Yes.
Yeah, they have to believe him on certain points, and those are going to be points that the government is going to say that they have corroboration for. Either they have they have conversations to corroborate, or they have documents. Because Michael Cohen is the only person who can speak to the criminal disguise of the documents. He was in all the key meetings. He is the through line. There has to be some believability on those meetings that he has spoken to. Like, we have that incredible Alan Weiselberg, the gross-up document where, everything's sort of cooked and here's how the payments are going to work. And then Alan Weiselberg and Michael Cohen then go to speak to Donald Trump about it. We have not heard from Alan Weiselberg. He's over at Rikers. He has not been called. So we've got Michael Cohen's word on that conversation with Donald Trump where he signed off on it. It's very important. And they just have to believe him on stuff where there's actually evidence. We just put it up on the screen that may have happened.
President Trump, are you going to testify? Yes. You plan to testify in your trial in New York?
Yeah, I would testify, absolutely. It's a scam. It's a scam.
The gag order stop you from testifying?
No, it won't stop me from testifying. The gag order is not to testify.
Do you plan to testify in court?
Probably so. I would like to. I mean, I think so.
Okay. After weeks and weeks of saying he would, it turns out Donald Trump is not testifying in his first criminal trial. After all, this morning, the defense rested its case after only one day, calling no more witnesses after Robert Costello. And I guess since it's Trump, no one's really surprised at that. No one's really that surprised. But just imagine, if you will, what the reaction would be if it were any other former president on trial, if you could imagine any other former being on trial, and they failed to take the stand. Back with me, Katie Pham, Danny Cevallos, Tristan Snell. Danny, as a defense attorney, I'm sure you would never put someone like Donald Trump on the stand because you, of course, can't stop lying. But comment, if you will, on the fact that he did not and what impression that might leave.
Well, back when he promised, all I kept thinking was, ever since the whole Mexico would pay for the wall thing, I didn't believe a promise that Donald Trump was going to make about whether or not he was going to testify. And by the way, when it comes to white-collar cases, often you have defendants who think, if I could just get on the stand, I could explain all my problems away. And as the trial wears on, they realize what they're really in for. Maybe Trump really believed he was going to take the stand. I doubt it. In all likelihood, he was never going to take the stand in his own mind, no matter what he even told his attorneys. But in a way, the only person who ever knew for sure was Donald Trump, because he has an absolute constitutional right to take that stand. And he could have decided right up until the last minute whether or not he wanted to. So really, it wasn't even that much up to his attorneys, although they could strenuously advise him not to take the stand. The bottom line is few people can handle the crucible of cross-examination. And most defense attorneys, contrary to popular belief, we're risk-averse. I do not want to snatch defeat from the jaws of victory. If I think I have a shot at not putting on a case and not putting on my client, I don't want to be that courthouse myth of the guy. Did you hear about that guy who put his client on the stand and torpedoed his own case? So there was very little chance that Donald Trump was ever going to take the stand, no matter what he promised.
Yeah, and the cross-examination would have been brutal. Let me play Donald Trump today. Let me just give you an example of why, because his brain don't work good. I keep telling you all that. Here's Donald Trump today.
The judge hates Donald Trump. Just take a look. Take a look at him. Take a look at where he comes from.
Kristen, take a look at where he comes from. Judge Marchand Judge Marchand is from Colombia. And He pointed that out. Take a look at where he comes from. That is where he comes from. I just want to point out that another judge who comes from Colombia is Aileen Cannon, the judge that's saving his behind in the documents theft case. Another judge who comes from Latin America is Judge Curiel, who Donald Trump disparaged as he was finding against him in, as you very much well know, the Trump University case. What do you make of disparaging the judge's race as a tactic?
Not a great one, but also quite on brand for him, right? I mean, at the end of the day, a lot of the outside the courtroom antics are really for him to play to the media and cult that surround him and to be able to hit his followers up for money. So, you know, pushing that racism button is probably a good way for him to separate his followers from their wallets a little bit more. So sure, go ahead and go there. It's not going to affect what's going on inside the courtroom, but it's a tell and an on-brand one for him. But also, Danny's totally right about like how difficult it is to get Trump to do anything. I actually think we might have seen what would almost be the impossible. The fact that I think Donald Trump's lawyers actually might have convinced him to do something they wanted to do rather than something he wanted to do. I think he wanted to testify and he got talked out of it. Maybe he did chicken out a little bit too, but I think he actually probably thought he was going to get up there and be the smartest guy in the room and explain everything. And I think maybe finally, after the disaster of his testimony in the E. Jean Carroll case a few months ago, he has now realized that maybe that wasn't such a good idea, and his attorneys managed to push him away from testifying.
I feel like Katie has thoughts. I feel it.
He was never going to do it, right? I mean, he's crazy like a fox. I think that he has a lot of screws that are loose, but I do think he's crazy like a fox. And so he was never going to testify. I just think what's ridiculous about it, though, is, you know, we know, because to Tristan's point, there's an entire ecosystem that exists outside of that courtroom. But I want to be very clear. You seat a jury based upon them not having preconceived notions about this case, and you kind of screen out the people that maybe have too much knowledge about this. But there are two lawyers that are on this jury. Those two lawyers may not be criminal defense attorneys. They may not be former prosecutors. They may be big law or corporate lawyers right now. But they know that right to testify, and they know what that means. If you weren't going to testify, Donald, then where's Alan Weisselberg? Why don't you ship him in from Rikers? Why don't you have him explain your side of the story? Because you knew that that was also a loose cannon as well. And so I think the jury, you never underestimate their intelligence and their common sense. You're supposed to leave certain biases and prejudices at the door when you come in, and you're cloaked with the presumption of innocence if you're the criminal defendant. But we all know that they're not stupid and they're not ignorant about the reality of who Donald Trump is. And so maybe they wanted to hear from Donald, because I think it's human nature to want to hear from the other side. But I don't think anybody credibly believed that he was going to take the stand and actually say anything in his own defense.
Let me play Lanny Davis, who used to represent Michael Cohen. He's making sort of his closing argument sort of would be, and I want to get you guys' takes on what you think the actual closings will sound like. Take a listen.
The facts speak without Michael Cohen. He confirms, but he doesn't need to be believed because he's corroborated. Fact one, both Mr. Pecker and Hope Hicks say that the money paid to Stormy Daniels was politically motivated. That is a fact from their testimony, not Michael Cohen. Fact two, the Weisselberg document lists all the money that Michael Cohen was reimbursed, times 2 divided by 12 are checks Mr. Trump wrote for $35,000. Those are facts without Michael Cohen's testimony.
Let me give each of you, I'm going to put 30 seconds on the clock for each of you. Tristan, I'm going to start with you first. Does that sound like what you think you will hear in closing arguments? And do you think there'll be any surprise jury instructions?
I think that is what we're going to hear. I think Lanny Davis was pretty much right on that. I think that the emphasis you're going to hear from the prosecutors is look at all these other witnesses, and the documents are even more important than the witnesses. I think that what we were talking about earlier in the show about all of those key documents, Joy, that you pointed out, I think the prosecution is going to go through those brick by brick by brick. Jury instructions, we got a little bit of a taste of it today from the talk from the pre-charge conference. I think one of the things that's key there is that the unlawful means that is at issue here, that the jurors can have different ideas about what that unlawful means were. So that I think that's really key there. It's basically, if they were falsifying records and up to no good while they were doing it, that'll get you there, basically.
Today, the defense rested in the New York criminal hush money trial where Donald Trump did not end up testifying. But Robert Costello, the former legal advisor to the prosecution's star witness, Michael Cohen, Costello did testify with the goal of undermining Michael Cohen's credibility. It didn't exactly work out that way. Instead, Mr. Costello ended up corroborating parts of Cohen's testimony. On May 14th, Michael Cohen testified, "I didn't trust him," meaning Bob Costello. "I believed, based upon all of our conversations, that he would immediately run back to Mr. Giuliani and that communication would be divulged to President Trump." Multiple emails read during Costello's cross-examination today confirmed exactly that, showing that Costello was indeed acting as a back channel to Trump and Giuliani, precisely as Michael Cohen claimed he was. Joining me now are Christy Greenberg, former federal prosecutor and former SDNY Criminal Division Deputy Chief, and Duncan Levin, former Assistant U.S. Attorney for the Eastern District of New York. Thank you guys both for being here tonight. There's like a lot of specific legal stuff I want to get to, but first, just on the big picture, Christy, was it a good idea to end for the defense to end with Bob Costello?
It was a horrible idea. It actually helped bolster Michael Cohen's credibility. I mean, anything that makes Michael Cohen come off smelling like a rose, you have to think that's a bad idea for the defense. But these emails today, I mean, oozing with slime. I mean, Michael Cohen testified, "This guy wanted to be my lawyer, but I didn't really trust him. I thought he was just working for Donald Trump." And sure enough, we get emails today where, the emails are pretty explicit. We've got to make it appear as though we're not acting under the instruction of Rudy Giuliani or the president. Like, it's in writing. And the defense knows these emails exist. So, why in the world would you call this guy? Putting aside all of the antics that also happened in front of the jury, where he was just blatantly disrespectful, not something you would expect of a lawyer as a witness, much less somebody who held my former position at SDNY as a former federal prosecutor. It's maddening. But, I mean, all of those things, the style and today the substance, it was a total train wreck for the defense.
Okay, in no uncertain terms, bad idea.
Bad idea.
Now, the stage we are at now, Duncan, is Judge Merchan is basically deliberating on a number of decisions related to the instructions that the jury is going to be given, which is very important, if a little bit dry. But this is kind of where the rubber meets the road, right?
Yeah, I mean, not all lawyering can be as sexy, unfortunately, as hush money payments and secretly recorded tapes. But this is more like reading the fine print of a contract. But it's so important because this is the way in which the jury interacts with all the evidence before it. And the prosecution, the Judge Merchan hasn't ruled formally on most of the requests, but it looks like it was a mixed bag for the prosecution and the defense. So the prosecution won a big victory today or I should say a somewhat big victory today.
A meaningful victory.
In some of this small print. The two of the elements of the offense are that the falsification of business records was done with the intent to defraud and the intent to conceal the commission of another offense. And it looked to me...
That's the felony charge.
And that's the bump up. And on that bump up, the prosecution won sort of two little victories. One was that those are not two separate things, that the intent to defraud and the intent to conceal the commission of another crime are the same thing.
Okay.
But the more sort of interesting thing is that it looks like Judge Merchan is ruling that not all of the jurors need to be unanimous in the way in which he covered up this conspiracy to promote an election by unlawful means, meaning that one juror could decide the Stormy Daniels payment does it. One juror could decide it was the Karen McDougal payment that did it. Another juror could say it was a tax payment that did it, and they don't all need to agree on it. So that gives the prosecution a lot of flexibility.
And that seems like something that Alvin Bragg foresaw, right? Because all along here, it was, okay, we understand what the misdemeanor is here, falsification of business records. To make it a felony, there needs to be that secondary step-up charge. And Bragg long maintained, correct me if I'm wrong, it could be a number of things. And that was not satisfying, I think, particularly to those of us in the media. It was like, well, what are the things? What is the thing that you're going to pursue? He never outlined clearly one thing, and it sounds like the judge said, that's fine. It could be a number of different things, and jurors can come to different conclusions.
Yes. The one caveat, which is still, I believe, an open question, is to whether those unlawful means must be criminal, which is what the defense is arguing, versus whether it just can be unlawful, meaning it could also be civil. And the defense was really key on wanting to have this willfully language kind of put in, meaning that you're acting intentionally, and that what you're doing is going to result in a violation of a crime, of the law. So that the judge hasn't quite decided on yet, but yes, I agree with Duncan. This is a win for the prosecution. It gives them flexibility.